All right, let's jump straight in. Today, we're wading into that very messy intersection of celebrity power, billion-dollar crypto collapse, and a legal chaos that follows when regulation just can't keep up.
Exactly. And our mission for this deep dive is to get past the headlines. We're not just looking at what happened in court.
We're looking at why.
We're looking at why. The recent dismissal of that big lawsuit against a major promoter, well, it really highlights the absolute anarchy in the digital asset space.
And these are gaps that government reports have now confirmed.
Yes. So by the end of this, you are going to know exactly why the legal system is struggling so much to figure out who's liable when a crypto firm just goes bust.
Okay, so let's set the stage with the core news. This all revolves around the legal status of former Dallas Mavericks owner Mark Cuban.
Right. A U.S. district judge in Florida just dismissed the 2022 class action lawsuit against him and the Mavericks.
And this is all tied to their big promotional partnership with Voyager Digital, which is, now completely defunct.
And it is so important for you, the listener, to get this right away. This was not a victory on the merits of the case.
Meaning the court didn't say he was innocent.
Exactly. The court did not rule on that. The dismissal was purely procedural.
Okay, hold on. Procedural. What does that actually mean? For people outside of legal circles, a dismissal just sounds like the case is over.
Well, it means the plaintiffs basically filed in the wrong location. The judge ruled they couldn't establish what's called personal jurisdiction over Cuban and the team in that specific Florida court.
So the court is just saying you can't sue them here.
Precisely. They're saying we don't have the authority to make these defendants answer in Florida, but the actual allegations that Cuban promoted a fraudulent service, they're still on the table.
And he could be sued somewhere else.
Oh, absolutely. Cuban's own lawyers have said they fully expect the plaintiffs to just refile in a court that does have jurisdiction. So this legal fight is paused. It's not finished.
Wow. Okay, that makes a huge difference. But while Cuban is getting ready for round two, the plaintiffs have actually been pretty successful against the other celebrities involved, right?
Absolutely. The class members have already secured some pretty significant settlements from other big names who were pushing Voyager.
We're talking about like former NFL star Rob Gronkowski.
Him, former NBA player Victor Oladipo, and also NASCAR driver Landon Cassill, they all settled.
And how much did they get?
Those settlements brought in about $2.4 million in relief for the class.
So a precedent for liability is already being set by the people who chose to settle. Cuban is really the main one left fighting this.
He and the Mavericks are the primary non-settling defendants, yeah. They could be facing a trial, maybe late 2024, assuming this whole jurisdiction thing gets sorted out.
Which makes their legal fight so important for understanding where crypto liability is headed.
It's critical. And to really get the scale of what they're fighting over, we have to go back to the collapse itself. I mean, you have to remember the peak.
November 2021, the whole crypto market was near, what, $3 trillion?
The massive market cap. And Voyager was one of the darlings of that whole era.
And then the crash came, and it was brutal. Voyager's failure was incredibly fast.
So fast. They suspended customer withdrawals on July 1st, 2022.
And just 5 days later, they filed for Chapter 11 bankruptcy.
The total losses for the people in that class action suit people who bought their tokens, who used their interest-bearing accounts. It was over $3 billion.
$3 billion? That is just staggering.
And what gets lost in that number is the specific way they were deceived. The key claim Voyager used to get all these people on board was safety.
Right. They use that magic phrase everyone trusts. FDIC insured.
It was everywhere. Their marketing literally had taglines like, your USD is FDIC insured, in all caps.
And they use that feeling of security, backed up by all these celebrity faces, to pull in billions from regular investors.
And that's where the deception was so insidious. Voyager was not a bank. Crypto assets, your Bitcoin, your Ethereum, their own VGX token, none of that is insured by the FDIC. Ever.
So what was the tiny grain of truth they were using?
The only thing that was true was that customer cash was held in an account at a real traditional bank, which meant your cash was only protected if the bank failed.
Not if Voyager failed.
Not if Voyager went bankrupt, lost it all on risky loans, or just folded.
So if Voyager went down, your U.S. dollars were gone, unless the bank they happened to put it in also failed.
Yeah.
That's a completely different kind of risk.
It is. And we now know from internal documents that the company knew these claims were potentially misleading way back in 2021.
The year before the collapse.
The year before. And they kept advertising it right up until the FDIC itself sent them a cease and desist. They knowingly misrepresented a core safety feature.
And when you read the letters to the judge from the bankruptcy case, The human cost is it's gut-wrenching.
Yeah.
These aren't just numbers on a spreadsheet.
No, they are life savings, retirement funds. We saw some truly tragic examples.
I remember reading about a couple who lost $50,000 in USTC.
And a father who lost 100 Ethereum. That was worth about $160,000 when they filed the letter. Money he had saved for his kid's college education.
And the letters are just filled with this sense of shame and anxiety from people who thought they did their due diligence. They saw a publicly traded company with celebrity backers.
You trusted what looked like a safe, secure system, and then the rug just gets pulled out from under you. It raises a massive question.
How does fraud on this scale even happen in the U.S. financial system? I mean, don't we have the SEC and the CFTC for this?
That is the central question. And the enforcement actions, while they were significant, they came way too late for most people. The FTC did ban Voyager from handling consumer assets forever.
And there was that huge judgment, a $1.65 billion judgment.
But it was suspended, which means it likely won't ever be collected. What's more important is that the FTC is still going after the former CEO, Stephen Ehrlich.
Not just for deceptive practices, right?
Oh, and this is key. They're also suing him for violating the Gramm-Leach-Bliley Act.
Wait, Gramm-Leach-Bliley, that's old school banking law from the 90s, isn't it? What does that have to do with crypto?
It's the law that governs how financial institutions handle your private data. The FTC is arguing that he violated the security rules in that act. It shows how regulators are trying to jam this square crypto peg into these old, round regulatory holes.
And at the same time, the CFTC is also suing him.
The CFTC, which handles commodities, charged him with fraud and registration failures in a totally parallel action.
So you have two different federal agencies suing the same guy for the same collapse.
And that right there, that highlights the core problem.
Which is
fragmentation. A 2023 report from the Government Accountability Office, the GAO, called this out directly. It said the U.S. regulatory system is critically fragmented. There are huge gaps, especially for things like crypto assets and stablecoins.
So when a company like Voyager or FTX is operating, who's actually watching them? The SEC does securities, the CFTC does commodities. If Voyager doesn't fit neatly into a docs, who's in charge?
Nobody. And that lack of one single comprehensive regulator means huge risks, like mixing customer funds with company funds. The thing that blew up FTX can just be ignored.
A real bank couldn't get away with that.
Not for a second. Alarms would go off immediately. But because no one had clear oversight of the whole entity, these risks just festered.
And this brings us right back to Mark Cuban, because the whole lawsuit against celebrity promoters hangs on the definition of a seller under the Securities Act, a law from 1933.
It's the whole ball game. That law is the only tool they have to hold people liable for promoting unregistered securities. The legal question is, was Cuban just an advertiser, or was he a statutory seller?
And how does a court decide that?
They use something called the Pinter v. Dahl test. A statutory seller is either someone who literally passes the title of the security,
Which would be Voyager itself.
right, or it's someone who successfully solicits the purchase, motivated by their own financial interest.
Okay, so Cuban definitely had a financial interest. So it all comes down to what solicitation means.
And that's where the legal ground has shifted dramatically. This is so important for you to remember. Lower courts have recently expanded that definition of solicitation to include mass communications.
You mean like YouTube videos and social media posts?
Exactly. YouTube, social media, public appearances, it's all potentially on the table now.
So just promoting a crypto deal on Twitter, even if you never touch the token, could now make you a statutory seller in the eyes of the court. That's a huge expansion of liability.
It is. It means every celebrity, every company that uses mass marketing for these products is now facing a brand new legal tripwire. If you get paid to tell millions of people to buy something that turns out to be an unregistered security, a court can now argue you solicited that purchase.
And that's why the other promoter settled.
That's almost certainly why.
So the big questions for Cuban are Voyager's products actually securities? And did his promotional deal, with the $100 reward for fans, count as solicitation under this new, broader definition?
And it all points back to what the GAO found. The system is fragmented and straining. It's forcing laws from the Great Depression to govern blockchain innovation.
Which is why they recommended Congress step in.
Explicitly, they recommended Congress designate one single federal regulator to oversee the crypto spot markets. They see it as the only way to stop this from happening again.
That is the perfect pivot to our segment, where we connect all this regulatory chaos to potential market opportunity. Time for our outrageous but plausible trade ideas.
Okay.
And a reminder, this is just speculative analysis. It is absolutely not financial advice.
I am very curious what you pulled from that expanded seller liability ruling.
Trade idea 1 is shorting influencer risk. We've just established that this expanded definition of a statutory seller dramatically increases the legal risk for companies that rely on celebrity promotion.
Okay.
So the pitch is to short publicly traded crypto firms whose marketing is almost entirely based on these huge influencer campaigns. The bet is that future SEC lawsuits or private lawsuits will drive their compliance costs sky high and make that business model just unsustainable. You're shorting the future cost of their legal bills.
I like that. You're using the legal system as leverage. My trade idea 2 is sort of the flip side of that. It focuses on the institutional response. Long regulated custodians.
So you're looking at the GAO report.
That and recommendations from the President's Working Group. They are both suggesting that stablecoin issuance should be limited to highly insured banks that are subject to strict rules on capital and liquidity.
So you're betting against the decentralized stablecoin model.
I am betting on centralization. The trade is to go long on the big traditional financial institutions. Your JP Morgans, your Goldman Sachs, the ones that are already building out federally compliant custody services for stablecoin reserves.
The theory being that Congress will eventually just hand them the market.
Exactly. The theory is that Congress will pass a law that mandates this kind of traditional banking oversight, and that regulation will create a regulatory moat around these old school players, effectively turning the stablecoin market into a regulated banking utility overnight.
Which would make it impossible for smaller, less regulated players to compete. Okay, to quickly recap the absolute key takeaways from this deep dive.
Let's do it.
First, we covered the procedural dismissal of the Cuban lawsuit, which doesn't resolve any of the core fraud claims. Second, we detailed the Voyager deception itself, built on those false FDIC insurance claims.
And third, we examined the growing legal risk for celebrity promoters, who could now be seen as statutory sellers under these expanded court definitions.
Which leads us to our final provocative thought for you to take with you.
As all this regulatory scrutiny focuses on liability, on centralization, on consumer risk, will the entire financial ecosystem pivot to a permissioned blockchain future? A future run by the same highly regulated traditional institutions we have today, completely sidelining the decentralized ethos that started this whole thing.
Is this the end of the dream of true financial freedom in the digital age?
That's the question.
A heavy question to leave you with,
Yeah.
but one that's being shaped by the legal cases we're watching right now. As always, this discussion was for informational purposes only. It is absolutely not financial advice. You had to consult your own licensed investment professional before making any financial decisions.
Thanks for joining us.
Thank you for joining us on this deep dive. Let us know your thoughts, and we'll see you next time.